Hollander and Department of State versus Knowles.
May it please the court.
It's just give them a minute to get a little quiet back there. Let the hubbub subside a minute.
I've learned not to take it personally when half of the courtroom empties out just before my argument.
We have to.
Your reputation precedes you.
May it please the court, I'm Barry Richard. I represent Marcy's Law for Florida, and today I speak as well on behalf of the Secretary. There's only one portion of Amendment 6 that's challenged in this case, and that's the portion related to victims' rights. And there's not much of a dispute with respect to the accuracy of the language of the summary regarding victims' rights, which is understandable, because notwithstanding the position taken by the plaintiffs with regard to a word count, it's really a pretty simple amendment. It does three things. It creates new constitutional rights for victims. It authorizes victims to enforce those rights within the criminal and juvenile justice processes. And it requires courts to act to further that enforcement on behalf of the victims. That's what it does. That's what it says in the summary.
But they don't. But you said it's very simple. It says creates constitutional rights, but it doesn't inform the voters that there is a pre-existing constitutional amendment that was passed by the CRC and then passed into as part of the Constitution 20 years ago, and it is abrogating what was stated then in broad terms into a 5-page, I don't know how many, very long list, 5 pages and 146 lines of text into the Constitution. And you're saying there's no issue because it says creates constitutional rights, that it doesn't reference that it's repealing the pre-existing constitutional amendment?
Well, Your Honor, it doesn't abrogate anything. What it does is it takes the three rights that were previously in the Constitution, it retains them, embellishes upon them, and it creates 9 new rights. So it does do what it says. It creates victims' rights, and it does not repeal or abrogate any existing rights. Now, there are existing rights, but I suggest to the court that the fact that the summary says it creates rights doesn't imply that there are no already some other different rights, and that conclusion by a voter would be irrational, and this court has never said that that's the case. It correctly says it creates rights, which it does, 9 rights that don't currently exist. The only argument that's made in the briefs with regard to this is the complaint by the plaintiffs that the amendment uses the word facilitate. It says the courts are required to facilitate the enforcement of these rights, and that word doesn't exist in the text of the amendment itself. But Webster's tells us that the word facilitate means to help happen, and what the amendment says is courts shall act promptly to afford a remedy for a violation, which is precisely what facilitate means. That's the only objection to this particular language. The main thing that the plaintiffs argue is not that the text of the amendment itself is inaccurate, other than what I just said, but that it fails to inform the voter of a series of currently existing rights of accused. I believe it does not. And what I suggest is that we review those currently existing rights and see if any of them are repealed or abrogated by this amendment, because I believe that they are not. It's not that difficult because they all exist in 3 sections of Article 1, 14, 15, and 16, and there are not that many of them. The first one is that accused are entitled under Section 14 to pre-trial release on reasonable conditions. The plaintiffs argue that this is impeded by the amendment because the amendment entitles the victims to have considered when a court is determining what pretrial conditions should be, the safety, welfare of the victim and the victim's family, and that should be considered in pretrial release conditions.
Mr. Richard, I mean, we're getting into the actual amendment, and I take it that those are constitutional issues that may have to be argued later on. My concern here, our concern, is the summary. And where in the summary does it educate the voter that none of these additional rights for victims of crime will in any way interfere with the existing rights of the accused, promulgated by the United States Constitution?
Well, I agree with you, Your Honor, and the argument that's being made here by the plaintiffs is that it does impede those pre-existing rights and that the summary does not tell the voter. My position is there is no material impact upon those pre-existing rights. I am not trying to get into the amendment itself. I agree, by the way. I heard the last one.
In the amendment itself, in Section 11E, at one point in time, the original version of the amendment included the sentence, to the extent that these rights do not interfere with the constitutional rights of the accused. That was typed over, excluded from the proposed amendment. And that was the only place in the entire amendment where that appeared. It would seem like that would be a sentence that would appear in the summary to inform the voters, yes, we're going to give victims all these rights, which is fine, but they will not interfere with the rights of the accused in the summary, which is where everybody goes to read to find out what it's about.
Yes, Your Honor, that phrase appeared after the original three rights, which were the rights to be given notice, to appear, and to be heard. And it was left out because it serves no purpose in the current amendment once it was replaced by this paragraph. The reason it serves no purpose is because nothing in this amendment, none of these victims' rights in any way adversely affects the right of an accused to appear, to be given notice, and to be heard. Nothing. So the fact that that was left out, this court has said time and time again, it doesn't render a proposal defective because it changes something. It has to have a material effect upon a pre-existing constitutional provision. That has no material effect, and the plaintiffs have not explained why it would have a material effect.
Well, isn't the effect in the prior amendment, it said as long as the rights don't interfere with the rights of the accused, and although every one of us has sympathy for the rights of the victim, the accused is not yet convicted of a crime, so they're still under our system of laws presumed innocent. Not only doesn't the amendment mention that the idea that these rights are dependent on it not interfering with the rights of the accused, but the actual amendment says that it is equating victims' rights and interests should be no less vigorous than protections afforded to criminal defendants and juvenile delinquents, adding juvenile delinquents on there. You don't see an issue with not the federal constitutional rights, because they cannot interfere with federal constitutional rights, but our state constitutional rights, that particularly the issue of speedy trial. Could you comment on that? The effect on defendants' rights that are previously were told that they can't interfere, and now the amendment itself says will be no less vigorous than the protections afforded to criminal defendants.
Yes, let me take that in order, and I promise I'll get to speedy trial, and I know you'll remind me if I forget. But in any case, that language was general language, and what it said was that the victim's rights of being given notice, appearing, and having the right to be heard shall not in any way interfere with accused rights. My point is that language never meant anything. This was a cleanup, because the victim's rights that originally existed, that exist today, that are in the Constitution, don't have anything to do with any of the specific rights in the Constitution of an accused. That's why we have to look at what those rights are under sections 14, 15, and 16. We can't say that this is defective because of some general language that we have some nebulous idea may affect something. We have to say, what does it affect? That's why you said that that this must be clearly and conclusively defective. And so what I was in the process of doing was going through those rights in 14, 15, and 16 to demonstrate that there is no way that any of these newly created rights will be adverse to those accused rights right now. I can tell you pretty quickly what the rest of them are. Section 15 has nothing to do with this. It involves presentment or information, and a child tried as a juvenile or an adult. Most of the issues are in Section 16. Section 16 guarantees to an accused to receive a copy of the charges. That's not affected by this amendment. To be informed of the accusation against them. Clearly, that's not affected. To have compulsory process of witnesses. That's not affected. To be heard in person at trial. That's surely not affected. Now, here's one that the plaintiffs do talk about. The right to confront an adverse witness at trial. The plaintiffs don't say that that's affected, but what they do say that generalized language that Your Honor was talking about might deprive of an accused of the right to take a deposition of an accused. Well, first of all, there is no constitutional right to take a deposition. It exists today by statute. It doesn't exist at all at the federal level. And what we're talking about is whether there's a material impact upon some other constitutional provision. But second, nothing in this amendment, nothing stops an accused from taking a deposition if the statute's permitted and the Constitution has nothing to do with it. The last thing is the one that Your Honor asked me about, which is speedy trial. In the original briefs, the argument was that this amendment somehow has an adverse impact upon an accused's right to speedy trial. It clearly doesn't. It says that the victim has the right to a speedy trial, but it certainly doesn't do anything to stop the currently existing constitutional right or even statutory right of the accused to ask for a speedy trial. But what's happened is over time, this argument by the plaintiffs has morphed. So that in the last briefs that we received, or the briefs we received after the trial level, the argument is not that it abrogates their right to a speedy trial, but that it abrogates some due process right of the accused to have a delayed trial when necessary to prepare their case. But it doesn't do that. If you look at what the new provision says, it says that the victim has the right to proceedings free from unreasonable delay. No accused has a constitutional right to an unreasonable delay. Judges today decide when a delay is requested by an accused whether it's reasonable or not. I don't question the fact that due process requires that an accused be given a delay when it's reasonably necessary to allow the preparation of a case, but that has nothing to do with the revision that's before us today, which only says that the victim is entitled not to be subjected to unreasonable delay. Courts today can and do deny requests for delay when they're not reasonable. That's the primary things that we're talking about here. But there are some others, and I don't know how much they concern the court, but I'll mention them in the time that I have. One of them is the argument by the plaintiffs that the access to records provision, the public records provision in Article 1, Section 24, is abrogated by a provision in this revision that says that a victim has the right to prevent the disclosure of information that might lead to the ability to locate or harass the victim or the victim's family. The problem with it is this. Article 1, Section 24 gives the legislature the ability to create exemptions, and the legislature has created an exemption that does exactly that. And I have to apologize for the court because when I reread my brief yesterday, I discovered that the citation was left out, but it's Section 119.071, subsection J, subsection 1. And what it says right now, which the legislature has created in its authority under Article 1, Section 24, is that it exempts from the public records law any document that reveals any identifying information, essentially. The home address or phone number, the office address or phone number, the identity of the victim. So this provision in the proposed amendment doesn't change any material constitutional right that an accused has.
Mr. Richards, Section 10B, State Appeals and Collateral Attacks, provides that in non-capital cases, appeals must be completed within 2 years. State appeals, direct appeals, and collateral attack appeals. and in capital cases, within 5 years. Now, I can see how the timeliness of can fall on the victim's rights based upon the given victims to closure. However, I don't see how the additional requirement that requires chief judges in each circuit and chief justice of the Supreme Court to report to the legislature, cases that are over the limit, the time limit. We're not getting into this separation of powers issue where you're at this constitutional provision will be giving the legislature additional authority in encroaching over the judicial branch. And if so, why is that not a big deal that should be in the summary?
Well, I'm a great believer in separation of powers, which I've argued to this court many times, sometimes successfully, sometimes not. But the fact is that the separation of powers doctrine is in the Florida Constitution, and whether we like it or not, the people can change that if they want to. And in this case, they can require the court to report to the legislature. Again, we're not talking about the merits of it.
I'm not talking about the merits. I'm talking about whether something that is that big should not be at least in the summary so people know we're changing the Constitution to change the separation of powers doctrine in Florida.
Well, it tells them that we're dealing with victims' rights here, and one of the things that it says is that there shall be a report. Frankly, I don't think that's so material as to require that it be placed in the amendment, but that's for this court to decide. I don't think it's a major intrusion, frankly, Your Honor. I don't even think it's a material intrusion on the separation of powers doctrine. There are instances right now, multiple instances, in which the court is required to report things to state agencies, to the legislature, that are not even constitutional. They're statutory, and this court has never held that they were unconstitutional.
Wouldn't it be a very different matter if the proposal gave a deadline that had no exceptions, so no possibility for exceptions? And arguably, that would be a significant, have a significant impact on the judiciary. And it might be something that would need to be mentioned in the summary, but that's not what we have here. This is something that allows establishes deadlines, gives exceptions that the judiciary can make, and just simply establishes a reporting mechanism of when those deadlines are exceeded.
Yes, Your Honor, there is nothing in here that denies judges the discretion to decide what's reasonable and what's unreasonable. Nothing. I see that my time is up. There's one other issue that I will address now, if the court would like me to, which is the single subject issue that was being argued by one of the amici, which I think is clearly inapplicable. It's well established long ago that single subject does not apply to the CRC. It's very clear that the Constitution didn't intend it. The effort to circumvent that is by arguing that there's some kind of a First Amendment right not to have to make a choice between alternatives that you don't like. There is no such First Amendment right. The cases that are cited, by the way, are the reapportionment cases. The U.S. Supreme Court has never held that such a right exists, and it would be what we would essentially be saying is you can never have a multiple subject amendment because it would always violate this, and therefore... Well,
here's the thing that's different, though, particularly in this one. You've got victims' rights in Article 1, and then the rest of everything is in Article 5. And what on earth judges interpreting statutes without deference to the administrative law has to do with victims' rights, only, except that maybe they both occur in a court setting, I think is what the concern is. I agree there's no single subject violation, but there is something about this that is this multiple unconnected subjects that's really putting the voter in some position. It's almost like it's worse than log rolling because there's nothing to do. The three are just completely unrelated. Now, maybe the CRC had this is a huge deal, as you know, every 20 years. They've never done anything like this, and so it's just unfortunate that this has happened because if it was decoupled, we might not be precisely where we are right now.
Well, I would suggest, Your Honor, that the very fact that they are so unrelated makes it easier for the voter to distinguish among them. It's not confusing. And we have to assume that the voter has enough intelligence to see that there are three subjects here. I think it was in the trial level or somewhere that I made the comment that this argument would suggest that the early Americans were incapable of understanding freedom of speech because it was mixed into the same paragraph as religion, assembly, and the right to petition government redress of grievances. We can't assume that the voters are incapable of reading three subjects in a short paragraph.
That's not what I was saying. I was saying that they have no logical connection. And so in that way, I think it causes great disservice to the voters of this state. You know, there are many judges that would like very much to have their retirement age raised, but, you know, to couple it with a, 5-page victim rights amendment that really should be a law passed by the legislature is, frankly, seems beyond what I'm sure the creators of the Constitutional Revision Commission intended, but that's for another day.
Well, that may be, Your Honor, but the creators said that they could lump together multiple subjects that were not the same. And we know that they intended it because there's only one place of the four where they said that that couldn't be done, and that's the initiative petition. So that's what it says.
All your time has expired. I will nonetheless give you the 5 minutes you sought to reserve for rebuttal.
Thank you, Your Honor.
Mr. Chief Justice, members of the court, my name is Mark Herron. I'm representing the Hollander plaintiffs in this appeal. With me today is Danae Brown, also representing the Hollander plaintiffs, and also Harvey Suppler, who is going to split this argument with me and focus primarily on the single subject bundling issues that have been raised by the Knowles plaintiffs in their litigation. As we all know, the Hollander plaintiffs asked this court to affirm the decision of the trial court declaring that the ballot summary and title of Amendment 6 is materially and misleading and removing it from the ballot. We all know that there are two issues before the court here today, and the two issues are whether the ballot title and summary fairly inform the voter of the chief purpose of the amendment, and whether the language of the title and summary as written misleads the public. The Hollander plaintiffs don't necessarily concede that the chief purpose of this amendment is victims of crime or crime victims or creating rights for crime victims, because it's a slippery slope, because you have three significant changes to the Constitution that are lumped together in one amendment. And so whether you can have a chief purpose or whether chief purposes is something for this court to decide when they are looking at these amendments.
Well, if you're going to say there can't be more than one chief purpose, you're essentially saying that there's a single subject requirement and maybe even something more than a single subject requirement, something more restrictive than that's going to apply to all of these proposals, regardless of whether the constitutional single subject requirement applies. Isn't that correct?
Well, as I sit here and listen to the arguments, I think that is an issue that arises in each case, is to what is the chief purpose of all these bundled amendments, because they are bundling, many of them are bundling disparate subjects. And so again, this is something for the court to decide as to whether the chief purpose is. We're just not going to concede up front that the chief purpose of this amendment is victims of crime. Now, with respect to the crime victims provisions that are in this proposed amendment, the Hollander plaintiffs do challenge several provisions in there and say they are not adequately noticed in the ballot summary and title. And this court has addressed some of those issues in its questioning of Mr. Richard. We believe and we assert that the ballot summary and title fails to accurately inform the voters of the effect on existing constitutional rights of defendants. And this court has focused on some of those issues in the sense that the proposed amendment strikes out language in the existing Constitution without giving notice that the rights of victims are to be tempered and considered subservient to the rights of criminal defendants.
But wouldn't you concede, Mr. Herron, that most of these rights of crime victims don't have any impact on the constitutional rights of defendants. This is just like, you can kind of have a list of the constitutional rights of defendants and a list of these, the rights that are created here. And it's just, they don't really bump up against each other. I mean, for most of them. Wouldn't that be true?
Well, the point of our argument, and I'll come back to maybe answer your question more directly, but the point of our argument is that a state constitutional right of defendants is being taken away by the language of this proposal. And it's not,
I'm
that?
also
What right is
interested
that?
in the answer to Justice Kennedy's question, so maybe if you could answer that, you would answer it for
Well, many
all
of
us.
them further expand upon the existing rights of victims. So
But my question was about where you think that you're saying it's taking away rights of defendants. And my question was, isn't it true that most of these victims' rights don't even potentially collide with any constitutional right of a victim? I'm sorry, of a defendant.
And I think we're talking past each other a little bit.
I get the same sense.
Because the language in the current Constitution is being deleted, and it's being deleted for a purpose.
You're talking about the language in the current Victims' Rights Amendment, but I understand that's being deleted. But isn't it the case that sometimes things get put in amendments that are just kind of really there to answer objections that are being made? They don't really have any effect. And it seems like to me that the burden is on you as someone's coming in here and saying that the people of Florida should be deprived of an opportunity to vote on this, is to show, in the connection with this argument, to show specifically what rights of defendants are being impacted or curtailed by this proposal. And when I look through it, I see on the overwhelming majority of these things, there's no potential impact. And the others that you kind of focus on, I don't really see that there is a collision or a curtailment of rights. So tell me specifically what constitutional rights of defendants are curtailed or defeated by this proposal.
I will give you two examples.
Okay.
One example is a speedy trial. Speedy trial. Speedy trial for the
You're talking about the
defendant.
speedy trial right of the defendant.
That is correct. Because the amendment gives the state an independent state constitutional right to seek a speedy trial over the objection of the defendant.
But the constitutional speedy trial right of defendants is a right for them to go to have a speedy trial. It's not a right to slow things down.
But they have.
Now, they do. You have an argument, I think, that there's a due process right for them to have adequate time to prepare for trial, correct?
My argument is not due process. My argument is based on what's in the amendment and the notice that is given to the people that the amendment affects and essentially overrules perhaps the right of defendant in the current Constitution to have a speedy trial or waive a speedy trial.
But I can't see that from the text. Show me where that is in the text. Because two parties in a case can have a right to a speedy trial. And that means the other side can't drag it out unnecessarily. And that means the court's got to get going. When one of the parties raises the right, the court's everybody's got to get saddled up and go. But the fact that both sides can do that doesn't mean that the right of one side or the other is adversely affected. I can't understand the argument.
Mr. Chief Justice, I think you're focusing on the effect of the amendment on every day. I'm talking about what should be in the summary and title to inform.
But if it doesn't have that effect, why should it have to be in the summary?
It does have the effect. It does have the effect of giving the state a state constitutional amendment. It's in the amendment itself, in the proposed amendment, to move the defendant to trial, notwithstanding the defendant's waiver of his or her right to a speedy trial.
Well, where in the current Constitution are you guaranteed a right to delay?
Again, it's not a right to delay.
Okay, well
it's a
then,
right to waive.
so if where in the Constitution obviously you have a right to speedy trial and you can waive that right, But I'm just struggling
And
to
again,
understand
I
how
think
that.
the argument has been focused on what needs to be told to the public in order to make an intelligent decision on the amendment. So one of the rights that we assert as being affected by this amendment that need to be disclosed is the right to speedy trial that's set forth in the current Constitution is being abrogated in a sense.
What
by this
other
amendment.
ones do you have? You've spent 20 minutes almost on this one. What else is there?
Okay, thank you, Your Honor. It fails to accurately inform the voters of the obligation of the judiciary to complete appeals and collateral proceedings
Okay,
within 2
but
years.
with respect to the rights, your rights argument, the only one that you assert is that it interferes with the defendant's current constitutional speedy trial right.
Not exactly. The other one would be it impacts the rights that are guaranteed to the public under Article 1, Section 24. It's in our brief. We made that argument, that this amendment amends the public records and public meetings provisions of the Constitution without giving notice to the public.
We're kind of, the question I asked originally, which and you can stop talking about it whenever you want to, but I sense that maybe I didn't make myself clear when I asked the question. I want to know what specific rights of defendants, and I think Justice Lewis wanted to know the same thing, what specific rights of defendants, other than this one we've been talking about a lot, and we'll move on from that,
Right.
what specific rights of defendants are curtailed or adversely affected by the proposed Victims' Rights Amendment? What else do you have on your list of defendants' rights?
Again, the clearest one, and again, Mr. Richard argued about some of them in his proposal, is that the amendment places victims' rights, eliminates the ability, the language of the current Constitution that victims' rights shall not abrogate defendants' rights. And so we don't know for exactly how this is all going to play out. My point is, that I continue to try to make to the court, is that the ballot summary and title needs to give the public notice of those changes. And that's what I said. Just two more things. And we believe and have argued that the title and summary mislead the voters by the language that it uses with respect to saying creating victims' rights. It amends victims' rights. It substantially expands victims' rights. And in our papers, we point to other provisions of the CRC or other proposed amendments of the CRC where the CRC, in its specific proposals, Amendment 8, for example, the one that you previously dealt with today, it talks about creating a term limit. And it did create a term limit because no term limit existed. In Amendment 10, it talks about creating a government agency where no government agency existed. In Amendment 12, the CRC is very careful to say it expands lobbying prohibitions in certain circumstances, and it creates lobbying prohibitions in other circumstances. Here, the court tries to hide the ball, tries to mislead the voter, try to put political rhetoric in the amendment that basically, by using the word creating, creates a false impression, we believe, that there is no existing constitutional right for victims. I see my time is expired, and I don't want to take Mr. Sepler's time.
Perceptive.
Okay.
Thank you.
Good afternoon, Your Honor. May it please the court. Harvey Sepler on behalf of Amy Knowles. With respect to the first issue, that is the statutory accuracy requirement, we're going to defer to the arguments that Mr. Herring has raised and that are in the amicus briefs. Other than to say, Justice Kennedy, I just wanted to address one quick thing, and I want to lose sight of where ultimately I want to go in the short period of time I've got. What I find particularly troubling is something that the court has already raised, and that is that there is a curtailment, if you will, as to the right to appeal and the right to post-conviction remedies. It still allows those things, but now there is the requirement of a reporting requirement. And in response to your question, Justice Kennedy, to the extent that could in any way frustrate or chill the defendant's rights to seek appellate review, and as this court knows, it's not always easy to get these things done.
Under 10B, we're really talking about the appellate courts, right? The reporting requirement has to come not from chief judges of trial courts at all. It comes from the chief judges of the DCAs and the chief justice of the Florida Supreme Court. So the courts they're talking about in 10B really are the appellate courts, not the trial courts. Isn't that correct?
It is my understanding, Your Honor, that this reaches not only to the appeal, but it also reaches to post-conviction
Well, any
processes.
post-conviction, to a district court of appeal or to the Florida Supreme Court comes from after the ruling by the trial court, denial of affirmance, and then what triggers the appeal is the notice of appeal, right?
Correct.
All right, so when the notice of appeal, once that's filed, then what the language of B says is in non-capital cases, they have 2 years, and in a capital case, they have 5 years. So isn't this just a clock on the appellate courts, the district courts of appeal, and the Florida Supreme Court so that they don't sit on the appeal and that there's not some untimely disposition of the case?
I think in theory it is to try to have some type of a check on the courts that they don't sit on cases. I can appreciate that. The answer is as I would disagree with you. As you know from the Florida Rule of Criminal Procedure, the time for, first of all, going back to this amendment, the clock starts running at that time of sentencing. Rule of Criminal Procedure it says that the defendant has 2 years from the time that the conviction and or the sentence becomes final, which means, I suppose, running through the appellate courts. So that the time for post-conviction relief hasn't arisen. Again, I don't want to take too far into where I need to be, but the clock starts running at the time of sentencing. The clock for the 3.850 doesn't start running until the conviction and sentence become final, which means we're working its way through the appellate courts.
But we're talking here in B, when you look at the language of B, it's talking about when these appeals must have been concluded by. And it starts from the notice of appeal.
But it's also, it says, though, a tax on judgment must be complete. So
Yes.
it's 2 years from the day of the appeal, both for the appeal and all of the post-conviction
That's correct.
A
proceedings.
collateral judgment, that would be a habeas for ineffective assistance of counsel, filed in an appellate court.
Again, this
right?
is something that I think that you all will wrestle with more than I can, other than to say, I know that Justice Kennedy asked several times, what things specifically can you point to? And I'm going to defer to Mr. Harris.
Let me ask you about the
Yes.
I mean, assuming that we would have to change our rules, the time frames for post-conviction relief in our rules in order to make this workable if it gets on the ballot and passes, is the issue, I thought, was whether it changes a constitutional provision. And since there's no constitutional deadline that would be affected, I'm wondering why it's relevant to our consideration here.
Is that when the court asked a number of times, what specific things can you point to about this amendment that in any way would implicate the defendants or the accused's rights?
But we were talking about existing constitutional rights.
I understand that.
Yeah.
And under Article 5, the defendant has the Constitution, the Florida Constitution, the defendant has very clear fundamental rights. To the extent, and there may be other things that Mr. Herron touched on, but they're in the briefs, but certainly to the extent that Amendment 6 could chill or frustrate the defendant's rights to exercise his protections under Article 5, then that is trouble. And then when you look at that in combination with the language that's taken out, which the court has already talked about, the language is not just a simple reference, we don't need it anymore, and so we took that language out. It's not that. That sentence says, and if you'll, apart from any political considerations, that sentence says that the defendant's rights shall trump the victim's rights if this amendment were to go through. It's not just something that's thrown in there. Any victim rights that will exist if this gets put into place are then subservient, if you will, to the defendant's rights. But let me, if I may.
Where does it say victims' rights would trump defendants'
Well,
rights?
that was my language. And the reason I said that is that in the way that I looked at that sentence, which has now been taken out, which is victims' rights, and their families have these rights as long as it doesn't conflict with defendants' rights. That says to me that defendants' rights would take, if the two were colliding. I know we're not there yet. You're not looking at the merits of this. But if the two ever did collide, at that point, the defendant's rights would
Well, it says specifically, I mean, there's two things that happen. First, you're correct. The prior amendment that's not referenced, that's excised, says to the extent these rights do not interfere with the constitutional rights of the
Correct.
accused. It's a very simple concept. Victims should have rights, but we've got defendants who, until they're sentenced and the appeal's final, are presumed innocent, as obviously you have devoted your career to those defendants. Now, though, it doesn't say that victims' rights will be elevated. It says that they're no less vigorous in the protections afforded to criminal defendants. So it's essentially taking the enumerated rights that will be in the Constitution, putting those enumerated rights in and saying they get treated at least equal to, so they don't say it trumps the
That was just
the
my term
defendant's
because
rights. Okay.
sometimes it's easier
So,
for
but
me
that's
to
still
think of things.
significant from the point of view of how a court
Well-
tries to balance the rights of an accused when there are these multiple enumerated rights.
Let me just suggest to the court, I didn't mean to devote that much time to this because I have another aspect. It's very important, and I use the term trump only because sometimes it's easier for me to think of things in common sense terms. To me, when I read that sentence, the impression that I got is if at some time in the future, and we're not there yet, but if at some time in the future those two perspectives should collide, the victim's rights would be honored as long as it didn't in any way compromise the defendant's rights and so on, as a matter of sort of common term. And I use the word trump, again, with no political overtones to this thing. But again, that's not what I wanted to talk to you about. And I appreciate you giving me time to talk about something that is conceptual.
Well, why don't you go to what you want to talk
Yes,
about?
thank you, Your Honor.
It probably would have been good to start with that.
You know, it probably would. These are ththings that we wish we had a redo. I've termed it in our brief as a constitutional accuracy requirement. That is to say that when we first looked at this, I looked at Florida Statute 101.161, and that's where most of the briefs were going. And when I started to talk about this with other people, that's where attorneys started thinking about first. Is the ballot clear and all those sorts of things? But there's another aspect to this thing. Florida Statute 101.161 really gets its conceptual genesis in the Armstrong case from a type of a constitutional accuracy requirement. Are we placing voters in a position where in any way their ability to exercise a free and meaningful vote is in any way frustrated? Are we putting them in a position where they have to compromise their votes in any way? Our article does not depend on Article 11, Section 3. The Secretary of State's position is almost entirely, it's a categorical response. That is to say, well, let's look at the Constitution. And let's look to see where in the Constitution there are provisions for single subject. And whether we call it single subject or we call it bundling, we come to the same place. Where in the Constitution can we look for the authorization for courts to conduct some type of a review like this? Well, the first thing we do is we go to Article 11, Section 3. That, by its very express terms, applies to citizen-initiated initiative proposals. So that the Secretary of State's position throughout has always been the same. It's not authorized. Courts need not look at a challenge to a bundling or requirement. Yes, Your Honor.
You have used all your time. However, in light of how you got to this point, don't leave.
I thought the clock went up.
I want to just tell you, I'm going to give you 3 more minutes.
Thank you, Your Honor. I'll try to speak quickly. At any rate, our position does not rest on Article 1 or Article 11, Section 3. Our position rests on the constitutional and the fundamental right to exercise a free and meaningful vote, and the constitutional right of voters to be able to cast one that is free of any arbitrary voting conditions.
Are you saying that the voters, the people of Florida, are unable to consider more than one thing at a time?
What I'm suggesting, Your Honor, is that, number one, they may be confused, and we've talked about already with the statutory authorization authority or accuracy requirement. They may be confused But more troubling to me is that they may be placed in a position where they have to compromise their vote in some way.
I mean, isn't that the way Democratic works? I mean, you vote for a candidate, and it's very unlikely that you would agree with every position of that candidate. You have to choose which, up or down. I mean, and the only way to get to what you're saying the voters have a right to do is to say that constitutional provisions have to go to the voters more narrowly than single subject, but one specific, identifiable, discrete change at a time in order to protect this right that you say exists. And I guess my question is, where do you find that right? What provision in the Constitution could you point to say that voters have that right to have?
You asked, I thought about the notion that when I go into the ballot box and I'm voting for somebody for office, I may like some of the things that he or she does and not like some of the other things, and how do I balance it out? And isn't that intrinsic to the voting process? But again, we keep in mind, as the McCullough versus Maryland case of this, we are considering a constitution. We are not talking about somebody who will take office or not take office, or will take office and then will ultimately be out.
Was the 68 Constitution the result of the Constitutional Revision Commission?
I can't answer that question.
But that was put to the voters all at once, right?
I think, as I recall, the Citizens Initiative Amendment came up in 72. Although, I mean, I'm certainly sure that I could be wrong. I have been wrong plenty of times before.
But isn't this really something that those who are opposed to some of these provisions, isn't that something that you really try to educate the public about? That, yes, you may like changing the age for judges to retire, but this other provision is something that really is going to wreak havoc with whatever, and you tell them that you've got to make the sacrifice and vote no if that's because this other thing is more insidious. Isn't that the kind of thing that you educate voters about?
Well,
what
I
you're
think
really
so.
saying?
I absolutely think so. I think the voter needs to know all the things that have been brought out with the statutory accuracy requirement. The voter needs to know about how it's going to relate to other provisions in the Constitution. But they also need to know that, as you say, that if it could in any
But
way...
that isn't something that we can do.
Well, to the extent that this court is going to look to this ballot title and this ballot summary as advising the voter of the implications, it absolutely is something that you can do.
I want to ask you one final question, and if Justice Lewis has a question, I'll recognize him also. Has any court anywhere ever adopted this specific theory that you have been talking about?
Well, I can tell you, and the law is a bit different, but I was very interested when I saw this. In Montana, this same law came up, and it was passed by voters. And then in 2017, in December of 2017, the Montana Supreme Court basically threw it out, even though it had been approved by voters, and they did it on the separate vote. Now, we don't have separate vote. I understand that. And the proposal...
Well, okay. I'm asking about the specific theory you've been talking about. And now you're talking about this case. It sounds like that's a different theory based on a specific provision in their Constitution. I'm talking about the specific theory you're talking about. Is there a case?
There is. This has come up.
This is where you either give a side or say, no, there's not one.
Well, okay. Then
Thank you.
The answer is no. Thank you.
Well, I
sorry,
do have
Lewis,
a question. You've been up here for 20 minutes, and I feel that you haven't had an opportunity to get across of what you're saying about the multiple subjects. All this is not, and I mean, you're being pounded with questions about log rolling, and are you saying that you have to have one discrete sentence for each amendment and that kind of thing. I'm hearing you say, and you correct me if I'm wrong, but I'm hearing you say that there is a point at which multiple things being placed within one proposal can create the type of ambiguity and lack of clarity that falls under the duty to have clear and concise summary and title, not a single subject violation. Is that what you're saying? And if it is,
Yes, it is.
could you please, as succinctly as possible, I don't want to draw this out, but as succinctly as possible, what is that confusion in this case?
Here's what I was going to suggest to you, and I hope this answers your question, Justice Lewis. Two scenarios, hypothetical scenarios, but in a brief sense, I think summarizes and characterizes our position. I go into the voting booth. I presented with a proposal that has three parts to it. I like Part B, but I don't like Part C. My options are don't vote at all, or decide, do I like this more than I dislike this? That is contrary to what we think of as a free and meaningful vote. The second part is, supposing that I have a proposal, three parts to the proposal, independent, distinct subjects in this proposal. Mr. Richard has the exact same proposal, exact same, words exactly the same. Mine is proposed through a commission process. His comes about through this as his initiative. His will be thrown out, and mine will make it onto the ballot. And that seems to be, I have difficulty in a conceptual way of understanding why that is and why that should be. Does that answer your question, Justice Lewis? No. No? I'm happy to take another stab at it.
Thank you, thank you.
Please, the court. Mr. Sepler closed by making the comment that it doesn't seem to be right or fair that there is no single subject, there's a single subject requirement imposed upon the initiative referendum, but not otherwise. And he makes an important point here. That's true. We know that difference exists in the Florida Constitution, and here's the point. The single subject issue is not constitutional. It's political. Nothing in the U.S. Constitution prohibits states from doing what they please with single subject or log rolling or anything else. It's a political issue that's left to the states. This state has made the decision, and this court has recognized it for many years, and that's the end of the story. The other thing I wanted to comment on was Justice Lawson's comment about choice. Choice, I have to really vigorously disagree with counsel. The necessity and the opportunity to sometimes make difficult choices is at the core of our democracy. And Justice Lawson made an excellent point. You have to choose between candidates, and sometimes it's tough. One of them favors abortion, but he also favors gun control. The other one has the mirror opposite. The voter doesn't have the right to say...
But that's when you know... Here, let's go back to this issue, which is about choice. And I know maybe the appellees glossed over it, but it still bothers me. It talks about creating constitutional rights for victims of crime. It says nothing about, and we discussed this, the pre-existing rights of victims that were qualified by the equal, if not superior, rights that have been honored in this state, in this country, since the beginning of our Constitution, now going to elevate victims' rights in this, it's called Marcy's Law, I guess, for somebody out in California, so this is part of a national law, it's something that was created in Florida, to say that, no, it's not to the extent that they interfere with defendants' rights, so that a court can make that decision. It's enumerating how many 10, 11 specific rights? How many? Of
There
victims.
are 9 new ones.
9 specific rights. And without saying one thing in the ballot summary, that it is taking defendants' rights, and instead of saying that it is to the extent that it doesn't interfere, that it's putting it on an equal, if not greater footing, because they're enumerated. That's the part that concerns me about the misleading aspect of this part of the amendment. And maybe you've answered it adequately, but for me, that's still the concern. It's a sea change in what it could do to the rights of the defendants in trials in the state of Florida through unknown consequences of these specific rights of victims.
Well, it says it creates victims' rights. That is accurate.
It adds to, what it should say is it adds to the constitutional rights already established, and then say, and not to the extent that it interferes with defendants' rights, but it will put the rights of victims on the same plane as the rights not of convicted felons, but of the rights of the accused.
Well, there are two issues that you raise, and I'd like to address both of them. The first one is, counsel did suggest that it should say amends instead of saying creates. That, if we had done that, the plaintiffs would be standing before this court and saying it's misleading because it doesn't amend existing rights, it creates new ones.
I don't know what I would say that it adds to the rights already set forth in this article.
Well,
That's
the
what it
question is
does.
whether it's misleading. And let me suggest an analogy. If I go up to a restaurant that says, we accept credit cards, it's not rational for me to assume from that they don't accept any other form of payment, that cash is now gone. One has nothing to do with the other. The fact that we're creating new rights doesn't mean that there are not currently existing rights. The other question,
But
by
it
the way...
struck those rights out, correct? I mean,
No, it didn't strike anything out. It moved them to a different place in the
So,
Constitution.
and the trial judge said that it did do away with previous rights, but that was just inaccurate. Everybody agrees that it did not strike any
That's
existing.
correct. It moved it to somewhere else, and in fact, it elaborated on
But
that.
where does it take, that's the part that says to the extent that those rights don't interfere with the constitutional rights of the accused? Where was that moved to?
It doesn't retain that, but as I said, that's meaningless because they never interfered with any rights. They never did. And so this is an example of taking something out that has no purpose. If the court doesn't accept that, it doesn't accept it. But the fact is that two counsels stood before this court and neither was able to answer the question of what particular right does it interfere with. It doesn't interfere with any. It certainly doesn't interfere with the three rights we were talking about that preexisted: the right to be given notice, the right to be heard, the right to be present. It doesn't interfere with them, which leads to the last thing I'd like to say on this issue of no less vigorous. That's general statements of things that don't have anything to do with reality. What difference does it make? I don't even know that we know what it means, but what difference does it make if it says the victim's rights shall be enforced as vigorously as the defendant's rights if, as Justice Kennedy says, they never bump up into each other? There's nothing to tell the voters because there's been no, we have to remember this is material impact upon the Constitution. There's no material impact here.
So when the last Constitutional Revision Commission put in the language, because they were concerned, presumably, that it was going to interfere with existing defendants' rights, they put that in even with all the lawyers and judges on the commission for no effect?
Well, one thing that we all know is we have no idea why the commission puts things in, just like we have no idea why the legislature...
Wasn't the prior Victims' Rights Amendment a proposal that came from the legislature?
I believe so, yes, Your Honor.
Not the CRC.
Right, it came from the legislature, and they added that in, and I suspect, having been in the legislature, somebody said, why don't we add this in? And somebody else said, oh, okay, I don't see a reason not to. But the question is, what did it do? Because you know, this, I don't have to tell this court, it said that an amendment has to be clearly and conclusively defective. Whatever that means, it's something pretty heavy. It doesn't mean just the fact that, oh, well, they didn't put something back in and we can't figure out what it hurts. So I suggest, Your Honors, that this is, if this proposal, if this summary is not clear, then we're setting a new standard that's far below clearly and conclusively. Thank you.
Thank you. We thank both sides for your argument, and that concludes this session of the Florida Supreme Court. Thank you.
All rise.